Good afternoon, everyone. Welcome to the latest installment of Civil Disagreements. My name is Tiffany Middleton, and I work with the American Bar Association in the Division for Public Education. The mission of the division is to advance public understanding of law, which is one reason that we are proud to sponsor this program, along with Reform for Illinois and the Chicago chapters of the American Constitution Society and the Federalist Society. So our discussion today is around a recent Supreme Court decision, Snyder versus U.S., and its bribes, gratuities, corruption, and everything in between. So the Civil Disagreements series is designed to address timely, potentially contentious topics and demonstrate, like we say, civil disagreements. So without further ado, well, we do need to take care of some housekeeping things. If you have questions, please use the Q&A button at the bottom of the screen. If you're an attorney in Illinois looking for CLE credit, we are approved to offer 0.75 credit hours for this, and so the survey for that will pop up at the end. Please go ahead and fill that out. We'll also make sure that you get it in a follow-up email so that you're able to get your certificate, which will be issued by Reform for Illinois. So next up, I'm going to introduce our program moderator, Elisa Kaplan, who is the Executive Director of Reform for Illinois.
I will never learn with mute. Hi, everyone. Thanks so much for taking time out of your busy schedules to join us today. I'm Elisa Kaplan, and I am the Executive Director of Reform for Illinois. We're really proud to be part of this program that represents the ability to have disagreements in a civil manner, which is especially important for all of us in this day and age. I'll get right to it. If you'd like more information about our hosting organizations, Kylie will drop them in the chat. Kylie, do you have those handy?
Yep, those will be coming in the chat in just a second.
Okay. And if you would like information about how to apply for CLE credit, we should have a link coming to you for that as well. And we are really excited about today's panel, which includes James Bopp Jr., Jenny Cantor, and Sharon Fairley. We have links to their bios as well, or we should. If not, you can find that information in the materials or in the registration. So we'll just get right to this rather than wasting time. We have a lot to talk about today, and I think it's going to be a really energizing and lively conversation. So why don't we start with James? Tell us about this decision. It came as a little bit of a surprise to some people, but how would you describe what the court decided?
Well, thank you. It came as a pleasant surprise to me. I filed an amicus brief on behalf of the James Madison Center for Free Speech. And we were arguing one of the issues, which is that the court should recognize that a quid pro quo agreement was necessary in order for there to be bribery under, crimes under these statutes, and which the court did hold. I think there's two ways of looking at this, and they address both questions. The first is whether this statute included gratuities in addition to what we would refer to as bribery. The difference being, of course, the corrupt state of mind and the explicit exchange of something of value for an official act, which is what bribery requires. where gratuity, no corrupt state of mind, no agreement, just certain gifts are just banned from certain people or for certain activities or in certain amounts, depending on the statute. And they maintain the difference and distinction between those two types. And the second is the question of what happens if the payment occurs after the official act occurred. I mean, some had argued that the statute would only encompass, even though you fulfilled all the other requirements, the payment to be prior to the official act. The court made it clear that as long as there was an agreement to accept, that the thing of value could be received after the official act had occurred. So I think it was a positive development in the law and recognize the distinctions that I think are important in this area.
Would anybody like to add to that, either in the description of the court's decision or to James's perspective that it was a positive development?
Well, sure, I can jump in here, which is so absolutely, this was somewhat of a surprise in that there was a circuit split on this issue, but the majority of the circuits were in the opposite direction and really relying on the language of the statute, where the language of the statute uses the term reward, which has typically been viewed as indicative of a gratuity because it's a payment that comes after the official act as a reward for the official act. And so most courts, as did the Seventh Circuit below in this case, relied on that language to say, yes, this statute does apply to gratuities and had held so. So that's one of the reasons why I think it was surprising in a way. So that's kind of my take on it.
James, how would you respond to Sharon's interpretation of the word reward and of the court's textual interpretation in general?
Well, they listed like 6 different reasons why that interpretation, that reward signaled that we were dumping the whole idea of a corrupt state of mind and the whole idea of a quid pro quo to encompass just a gift. And one of those, which I thought was pretty persuasive, there are 2 federal statutes on this question. One that apply to federal officials, and of course bribery is one of those, which they used as the template. But the other is a gratuity statute. The traditional classic, you just can't give a gift in certain circumstances or in certain amount or from certain people, okay, to a public official. And of course, the gratuity is considered much less a serious offense because it's really prophylactic. It's not that somebody actually was influenced, but there's just a sufficient concern about influence and a sufficient concern about personal gain, on the public good, that it ought to be banned, where bribery is a much more serious offense. But then the court said, well, if we interpret this statute that applies to state and local, well, we're conflating these 2 together into a much more serious offense. And so that was pretty persuasive to me. They also took into account the federalism concerns, that here we are, the feds coming in and criminalizing activities of state and local officials that is traditionally matters that are within the purview of the state and local governments, not the federal government. It's a real intrusion into sovereignty of those government agencies, those governments. So that was pretty persuasive. Fair notice was a good point too. And the final point that I worry about a lot, and the court has mentioned in other cases, is the democratic concern. Our representative government presupposes interaction between constituents and public officials. The public officials will be attentive to the concerns of their constituents, maybe take action with respect to that, and of course, receive, as in this case, campaign finance contributions. You know, that's perfectly legal and appropriate. And we just have to be very careful about now throwing a big criminal gloss on top of all of that without very clear guidance, and which the court said didn't exist here.
Ginny, would you like?
Okay.
Oh, go ahead, Sharon, and then Ginny.
Well,
Sure, sure.
oh,
Go ahead, Jenny.
well, so I just have to interject myself here because I think one of the things that so offended me about this statute and not the decision is the fact that it seems to completely disregard the fact that these officials, state and local officials, are administering programs that are paid from U.S. taxpayer funds. So this is not something that just can be, corruption at a state and local level. When it involves U.S. federal taxpayer money, the corruption cannot just be addressed by state and local officials, particularly when it involves, contracts worth over $1 million. And the individual, the state or local government official actually solicited a $13,000 payment in consulting fees. So anybody who thinks that this is, that somehow the federalism argument is persuasive is just, totally unsatisfactory to me. And so I just want to reject that outhand. I also think, I was really personally very persuaded by the dissent, both because she focused on the text, as Sharon pointed out. The dictionary definition of rewards clearly encompasses what we think of as a gratuity. And the text requires a corrupt mens rea. So it's not like you're imposing a penalty for something that doesn't have a very significant mens rea. And I'll just stop there and and I also want to say something, and I'll add it later, about the statute that 666 is based on. I totally disagree that it's based on 201. I think it very clearly is based on 18 U.S.C. 215, and it uses the very same language with respect to corruptly, with respect to intent to influence, or reward. So I just, I was surprised. I was shocked at the decision and extremely disappointed. So that's all.
Ginny, can you back up and just explain what those two statutes that you identified are for the people who aren't intimately?
Okay, so the 18 U.S.C. 666, which is the statute at issue in the Snyder decision, is an attempt to hold individuals at the state, local, tribal government level accountable for theft or bribery, or I believe gratuities concerning programs receiving federal funds. And they have to receive a significant amount of monies, and there are certain transactions that are exempt. 18 U.S.C. 215 was actually enacted, and the dissent goes into this. It was actually enacted just a few months prior to 666, and that is focused on the receipt of commissions or gifts for by banking officials for procuring loans. So, but the language is virtually identical. And this was what was so galling is Justice Kavanaugh, he reduced it to the discussion of 18 U.S.C. 215 to what he called the null data point. And I mean, if it wasn't so sad, it would be amusing.
Well,
Sharon,
I think So I think it's precisely because he knew that the decision was going to be quite controversial, was why he listed 6 reasons to explain, why he came out the way he came out, starting with the text and the word reward. He says, well, look, reward doesn't only apply to a gratuity, it also applies to a bribe that was paid after the fact. So that doesn't solve the issue. And then he went on to explore the other reasons for his justification, the history of the statute, the structure of the statute, the punishment, as James talked about. He points out that looking at the federal statute that criminalizes gratuities, the penalty is only 2 years, which is way lower than the 10-year penalty for a violation of 666. And he didn't think Congress would intend to provide that kind of serious punishment as applied to gratuities. And then, of course, the federalism concerns. But then we get to the fair notice. And I think if you listen to the argument in the case, I think that's really what was doing most of the work in getting to the outcome that was gotten to here. And it's because it really boils down to the meaning of the word corruptly. And I feel like the government was just not able to articulate a real solid reason for how to interpret the word corruptly in this context that would give individuals fair notice about which kinds of gifts are going to be illegal versus those that don't. And so I think that was really what was doing most of the work in getting to this outcome.
Yeah, I think, Sharon, you made a really important point, and that is part of the problem that the government had was there's no question that there's a lot of gifts that are completely innocuous, even when given by a prohibited person, that are completely innocuous and shouldn't be punished. And then that's why you have in these gift statutes, you usually have, a general rule, but then you have a whole laundry list of, it's okay, it's okay in all these different situations, family member, et cetera, et cetera. So there was in the gifts, a bribery is never okay, but gifts can be perfectly fine, and that you need to make a distinction between those that are and those that aren't. And of course, none of that work was done in this statute, which also suggests strongly, in my view, that it was not intended to cover gifts. And then the fallback was, well, just trust the government. We'll and of course they rejected that and have done that in other cases too as well. In fact, one of my cases, Wisconsin Right to Life, one of my cases, Citizens United, that argument was being made. Trust us to protect for the First Amendment rights that this statute seems to be broad enough to impinge upon. And Chief Justice Roberts said, we do not rely upon federal bureaucrats to protect the First Amendment. So there's also that too. As soon as you get into the area of recognizing that some perfectly innocent and appropriate conduct could be criminalized by a statute, you then get into this wariness of the courts, justifiably, to uphold a statute that is so broad that would do that, when you could pass a narrow statute with the appropriate exceptions.
Sharon, am I to take from your description of the court's decision that you agreed with it?
Not necessarily. I think that the use of the word reward to me, carries the day here because of the way it's interpreted in the other federal criminal statute and in general. So I'm not saying I agree with it at all. I'm just saying this is kind of the takeaway and my response in terms of listening to the argument, what I think was really compelling to the justices here. And as James has aptly described, the court really takes very seriously its gatekeeping role in, sort of making sure that prosecutors are not using federal criminal statutes to criminalize what is ordinary, what they believe is ordinary political conduct. And that's because politics is essential to our democracy. And so, the court has historically been, seeing themselves as gatekeepers in this endeavor and trying to make sure that there isn't government overreach when it comes to this. And so this is just another case in a series of many that we've seen, and a couple in recent years, actually recent terms, where the court has sort of reined the government in a little bit.
Yeah, and
Jenny,
I'm sorry, go ahead. I'm sorry.
go ahead.
Well,
Go ahead if it's.
and to Sharon's point about a series of cases, you really need to read Snyder versus U.S. in light of U.S. versus Sun Diamond Growers in 1999 and U.S. versus McDonald in 2016, because they each address one or more parts of this and come out the same way, in a fairly protective, fairly and many of the same concerns are explicitly expressed in those cases of federalism and fair notice and democracy. So this is pretty consistent, in my opinion, with this line of cases.
Jenny, I take it from your previous comments that you don't agree with the decision. Would you like to respond to some of Sharon and James's comments here?
Well, what I'll say is I do agree that it's consistent with the line of cases that James mentioned. And I think if you believe that public officials should be given greater latitude to engage in what I consider corrupt behavior, then you would be more sympathetic to this. I think that the McDonald decision highlights one of the problems that actually evolved out of Sun Diamond. And in Sun Diamond, one of the issues, which I guess it involved a former Secretary of Agriculture who accepted, like, I think, football tickets or some sports tickets. And the question from what we call a prohibited source, somebody who does business before the agency. And the question there involved whether or not there was an official act. And because there was no identifiable official act, and before Sun Diamond, basically any federal official who accepted a gift because of an official position, it would have been covered by the illegal gratuity statute under 18 U.S.C. 201C. After Sun Diamond, it wasn't enough to show that somebody was giving you a gift because of your official position. It had to be because of an official act. And out of that case law, the McDonald case arose. And if you were a government ethics official, like I was at the time, the McDonald case seemed to clearly violate 201C and to the Bribery Act, because there was very clearly gifts being given to Mrs. McDonald and Governor McDonald, and to us it appeared as if they were for official acts. The gifts at issue were high-end designer gowns and handbags, and the financial load of $15,000 for their daughter's wedding. The official acts were holding events in the governor's mansion that for the benefit of promoting the donors' products, and also Governor McDonald arranging meetings with his subordinates and his staff members to meet with the donor in anticipation of getting a more beneficial treatment for his product by the state. And for all of us who worked in the government ethics field for years and years and years, this squarely seemed to be considered an official act. But the court held otherwise, and much to our dismay. And so what we see is this notion that public officials are being held less accountable for what are perceived to be corrupt acts. And I'll also say, over the last 10 years, the number one fear of the American people is that your government officials are engaging in corruption. And so now when you see this Snyder decision, you really, you see the trajectory, and it completely undermines public confidence in the functioning of our government. It undermines the integrity of our government programs. So I think that's something we all want to be concerned about.
Sorry to interrupt. I was just going to say, I think part of the frustration with the decision, and also similar to the decision in McDonald, is that the behavior, the behavior on the part of the public official in both of these cases was quite egregious. I mean, it was really over the line, right? In Snyder, this mayor is basically shaking down this trucking company that he had helped grease the skids to get contracts so that from, the city was going to buy these garbage trucks from. And, he did all these things to make sure that these contracts would be awarded to this specific company, down to making the specifications for the trucks so tight that literally this was the only company that sold these items, right? And then, of course, after it's done, he hits them up and says, I need $15,000. To pay my taxes and stuff. So the conduct was quite egregious, right? And the same with McDonald, right? It was egregious. The mayor's wife was like, oh, I like your watch. And the guy was like, well, would you like one for your husband? And she says, yes. So I think that's part of what's really frustrating when we see the court taking these cases that are like seriously way over the line and saying, you know what? There's a problem here, and we're gonna rein things in. I think that's part of the frustration.
Yeah, but I think that, and I agree with that frustration, but a properly drafted gift law would cover Snyder, would cover McDonald, and and so in other words, this could have been punished through a properly crafted gift prohibition law, So I think that's the way to go with this, if not trying to shoehorn this into the bribery statute. Now, secondly, with a couple of Virginia's points. One is, I agree with the view of the general public that we should have a healthy skepticism of people in government, and assume, that without proper, supervision and accountability and transparency, that they're likely, that some of them are likely to do corrupt acts. And so I think that's healthy in our democracy. I think that's healthy approach to government because it just simply accords with human nature, and we ought to have that. So third, next is, of course, what McDonald held was, arranging, hosting an event or speaking or arranging a meeting did not involve what the court said was, quote, making a decision or taking an action on a pending or impending government matter or agreeing to do so, which must involve a formal exercise of government power. I mean, meeting with your constituents, speaking at their events, arranging a meeting with some governmental official. These are the things that every member of Congress has a staff employed by the government to provide for their constituents, those very kinds of services. So you just have to be very careful in this area, and which takes me kind of to a disagreement with Virginia. And that is, what is corrupt? She uses that word, okay? Within the progressive view, a governmental official that is influenced by the general public to make decisions about the exercise of government power is very likely to be viewed as corrupt, because one of their principles is that they want people to essentially be.
I'm going to interrupt you, sir, because I don't want you to put words in my mouth, but I will listen to how you define corruption rather than have you, and I will tell you how I define corruption.
Okay, well, I'm not accusing you of being a progressive. I'm talking about the progressive view,
But
of President Wilson. I mean, and
well, then talk about President Wilson.
I'm talking about the progressive views of people like President Wilson. And you're certainly free to disclaim that you're a progressive. But one of the ideas is that experts are the best people to make decisions, including in a democracy. Secondly, is that they should not be influenced by the general public, etc., in making those decisions. So, I've litigated numerous campaign finance cases where the question of what is corruption is litigated. I've won 9 cases in the U.S. Supreme Court on this subject, including attacks on contribution limits that were viewed to be too low. And that is that basically the argument was in those cases that even a contribution limit of $400 to somebody running for governor of Vermont could unduly influence that person once they became governor. Supreme Court struck that down, said it was way too low. People are not, governors are not for sale for $100 or $400. So, and anyway, that is an argument that I've dealt with, and in many cases successfully. And that is a very broad definition, in my opinion, of corruption. All right, influence, being responsive to your constituents, should not be viewed as corruption. All right, and so I would consider it to be a more narrow definition of a quid pro quo. The Supreme Court, even including in the campaign finance context, now that defines corruption to require a quid pro quo, and that's really what we should be looking at.
Thanks, Jenny.
Yeah, I apologize if I jumped too quickly. I thought you were.
Are you offended?
No, I just wanted to make sure that you weren't defining my own views. And if that wasn't your intent, I greatly appreciate it. And I apologize for interrupting you. I just needed to clarify that, and you kindly did. So to me, what corruption is the improper use of public office for private gain to benefit your own or for others, financial interests. And so I think one of the reasons these line of cases are so important to me is, one, I think almost everybody has an intuitive sense of what is right and wrong, and what is acceptable and what isn't acceptable from public officials, in terms of conduct of public officials and in terms of accepting gifts or not. And I think what struck me about the Snyder decision was the context in which it arose. And I, like many public officials, and I've advised hundreds, if not thousands of them, they usually have like visceral reactions to scenarios. And I actually think the Snyder decision is a visceral reaction that they have to their own dealings of government ethics. And first and foremost is they have no enforceable code of ethics code, okay? And I think that's led to a lot of problems. But I also think you have to look at it in the context of what's become public over the past few years regarding the ethical conduct of the Supreme Court. And in particular, the series of articles by ProPublica, which exposed the millions of dollars worth of vacations, yacht trips, salmon fishing trips, Adirondacks resort trips that Justices Thomas and Alito took over the past few years. I don't think any of which those were disclosed. The loans that were, or the house that was purchased for him by a friend, so his mother could live rent-free in it. So there were a lot of gifts coming into the Supreme Court. And I think one of the things they have to struggle with, and some of the gifts were apparently made by, persons who had business, through their companies or, their some of the programs they support, they had interest before the court. And they have to struggle with, well, if I'm accepting millions of dollars worth of gifts, and this is a $13,000, fee that's been given to somebody, is what I'm doing crossing any lines? And, so I think that's where it comes from. And I think that's something you have to step back. And I think that's where we're at now. I think that they've opened the door now for state and local government officials to be able to accept gifts after the fact. And there may not be, and even though the governments are responsible for administering millions of federal taxpayer dollars, the federal government will not be able to hold them accountable.
Jenny, is it fair to say then that you don't agree with James's definition of corruption, that it requires a quid pro quo?
Oh, absolutely. I mean, it's basically that definition means that only somebody who's stupid enough to go on the record, and a public official who's stupid enough to go on the record in some fashion to say, I'll do this for you if you do that, or if you give me, something of value. And that's, some people may question the intelligence of public officials, but I don't in that regard. I think there's clearly a way to circumvent that. And so instead, they can be rewarded, for taking official acts. But, according to James, and I certainly, I don't like overreaching, okay, at all. But according to James, I mean, the federal government has no business holding these individuals accountable. And I think that promotes distrust. That's all.
Well,
James, do you have a quick response? And then I want to ask Sharon if she's got any reactions to all of this.
I'm sorry I haven't made my position clear, Virginia, and I will. Number one, I have no objection and in fact support gift bans from, for instance, people doing business with the government. A properly constructed gift ban is the way these things are dealt with. We're talking about bribery, which is, in terms of penalty and under federal law, is 5 times more serious, than a gift, an improper gift, and therefore requires more specific intent, mens rea, and some sort of exchange. That doesn't have to be explicit. It can be from the circumstances. The prosecutor could prove it, not easily, but could prove it. But that's the way to handle this. Your complaint about these gifts is that you don't think they should be given the gifts. Well, do a gift ban, okay, and off we go.
Jenny, quick response, and then Sharon.
Well, I'd like to see the Supreme Court step up and administer their own gift ban and absolutely ban any gifts, accepting any gifts. And then I think their case law and their decisions would have greater credibility in this area.
It sounds like, Jenny, you think that this statute is a gift ban, at least a gift given solicited with corrupt intent.
I absolutely agree with the dissent that this statute should have been, based on its text, it should have been enforced. And if you look at, and I think they said there was a corrupt mens rea. I mean, the statute has a corrupt mens rea in it. And then you also look at the sentence. It was 1 year and 9 months, which is well within the range of the illegal gratuity statute of 201.
Sharon, any reactions to all these comments?
Sure. So, I mean, I definitely sympathize with Ginny's point of view about the ethical challenges we see at the court these days, and have been, extremely disappointed to see the court's reluctance to, put in place, regulations that that govern every other federal employee. Why, why should they be any different? So I definitely sympathize with that view. There's no question about it. But I do think when I look at this particular decision, to me, it just seems like it's just part of the same approach that the court has been taking for decades when it comes to how it views corruption. So when it views corruption, they say, we know bribery is bad. And so we know that's bad. And so that's where we're going to draw the line, because when we get beyond that, we're just not so sure. And we can say that, people should, officials should know when they're getting a gift that's, illegal versus not. But that was part of the problem, is that, when we interpret the word corruptly, the government was basically saying, well, it means wrongful or immoral. And the court just was not satisfied with, like, well, how do you draw that line about how do people know what's wrongful or moral? It's a very vague, these are vague terms and so they were worried about the fair notice. And of course, we see the court taking that position all the way back in 1987 in McNally, when it first struck down the honest services version of mail fraud. And then again, after that statute after Congress said, no, we really want this, right? And then they created the honest services statute. We had Skilling, where they said, look, we're gonna say honest services fraud can only be done by bribery and kickbacks, because that's what we know is corrupt. We feel confident we know that's corrupt. And once you get outside of that, it's really hard to draw the line. So I think, this case to me is kind of just along that same line. Same thing with McCormick, where they said Hobbs Act extortion only applies to campaign contributions where you can prove a quid pro quo. Again, bribery, quid pro quo, we know that's corrupt. We're going to draw the line there. So to me, it's just part and parcel of the court's view of these things. I'm not saying I agree with it. I don't, but that's kind of, they have been consistent.
Jenny, what do you think about the idea that it's too hard to define corruption or corruptly, and that the government didn't offer a good enough definition? Do you feel like there's enough background in the case law or in other statutes to define corruptly? And what do you think more generally about the fair notice argument that this statute could catch a bunch of innocent gifts? Like, I think one of the examples, if it wasn't exactly this, was something similar to some junior softball players taking their coach out for lunch after a successful game. What do you think about that argument?
I kind of feel like they protest too much, is my reaction. I mean, to me, it's very clearly, when somebody has just been awarded $1 million and then they go out and they seek a $13,000 payment, like, that's, it's pretty much on its face corrupt. And I'm not at all, I kind of have, I step back and I just don't know how you cannot find that as being covered by the statute unless you have your own, like, almost a distorted frame of mind, and you're coming from, like I said, I think people look at this from their personal perspective. And I think that in some ways, they have to be accountable for their own behavior and distinguish what they've done from somebody who has engaged in wrongdoing. And I'm not sure that they can. And I think that's why they're having so much trouble with it.
Well,
I want to move on.
I think it's an honest disagreement. The court just has not accepted Virginia's argument. And we, as Sharon points out, we're talking about decades of decisions. Republicans, Democrats, liberals, conservatives. I mean, McDonald was unanimous that have consistently approached it in this way, not to Virginia's liking, but it's not because they have a distorted thinking. They just don't agree with you.
But I think the American people do. And so it tells me that the court is not listening to the American people. And I think the American people know what's right and wrong. And the court is turning itself upside down, trying to make these distinctions. But I think I'll just say it, I think they lack a lot of common sense.
Jenny, it sounded
One
yeah,
other point, I'm sorry, because
okay.
we're having a nice discussion here. The most definitive expression of the will of the people of the United States is not your polling or your intuition, but it is the United States Constitution. You know,
And, oh, sorry.
it says it right, right in there, about due process and the protection of the four indispensable democratic freedoms, and the structure reflects federalism, and fair notice is not something just to blow off based on somebody's intuition. I mean, what we're talking about here is arbitrary and capricious enforcement of a serious federal criminal law that, if it's overbroad or vague and permits that, and the courts permit that, is a tremendous weapon that can be used by government against the people. And, so these aren't just like whatever. These are really important concerns.
Okay, and I will say this, that this statute also reflects the will of the American people because it was enacted by Congress to address political corruption. And the fact is that I do believe that it should have been enforced. I think the court, because they don't themselves, they're not governed, they're not really governed by an enforceable code of ethics. So they kind of give themselves free rein. And I think because of that, they've lost sight and they've lost the confidence of the American people.
Jenny, do you think that that my example of some junior softball players taking a coach out for lunch, they could get ensnared in this statute?
No, absolutely not. And by the way, you look at what, you look at the sentence was well within the illegal gratuities penalty under 201C. And of course, no prosecutor is going to bring a case against the baseball coach, okay, for being taken out to dinner. And nor should he or she be prosecuted for that. But I will say this, that is the purpose of the courts, because if that person was prosecuted or it was given a very lengthy sentence, for example, if Mr. Snyder had been given a 15-year sentence, I would have been more concerned about it because there wouldn't have been a quid pro quo, but he was given a sentence well within the range.
And do you think that
we're to trust those very public officials that you consider so corrupt that you need a very broad definition of corruption and a very broad statute to rein them in? We should trust them not to use these statutes as weapons against, their opponents or whatever in a corrupt way. I mean, that it's inconsistent. Good judgment and beneficence on one hand, and at the other hand, think, man, we got to have all these laws to hammer these people down.
Well, it's better than throwing the whole shebang out, right? You got to trust somebody. You've got elected officials, members of Congress, who enacted a statute that, by its plain text, should be administrable. You have an enforceable. You have judges who preside over these cases who, are appointed for life terms after being vetted. I mean, you want me to trust the Supreme Court. I don't know why I shouldn't trust the judge who presided over this case or the prosecutors who brought the case.
Am I understanding correctly that you believe that the reason that softball coach wouldn't get caught up in this is because of the word corruptly, in addition to prosecutorial discretion, that there is built into the statute a corrupt mens rea? So you believe there is significant safeguard in the statute?
I mean, there's way too much, there's way too much, too many problems out there. Okay, number one, for anybody to waste their time prosecuting a baseball coach. So, you can go off at, I just think that's a very, I don't take that argument very seriously.
So it sounds like Ginny believes that the plain text of the statute would encompass this gratuity. Sharon, you agree the text of the statute would? You said you don't agree with the decision. So do you believe that the plain text of the statute would allow prosecution of gratuities?
I think, obviously it's going to depend on the facts of the case. I do think that, when we talk about, did this ruling completely rule out prosecution of after the fact payments? I don't think necessarily that has all gone away. And here's why. I think that there are always going to be ways to prove through circumstantial evidence that there was this agreement that existed, or at least an acknowledgement, an understanding that existed before the official act was undertaken, and where the payment comes after. And I think that the prosecutors may be able to take advantage of that avenue. Now, there's always going to be situations where you can have, the nod, wink thing going on, and the payment comes after, right? And that those situations we're not going to be able to use this statute for sure. But I think that there are some situations, and also, as was found in the Madigan case, at least that judge found that what's called the stream of benefits theory of bribery has survived Snyder. So in other words, and prosecutors don't necessarily have to say, tit for tat, like this payment for this act. You can have a stream of benefits coming for a stream of acts, and that's going to be enough to show that there was a bribery, there's a quid pro quo situation there that's going to, fall within the purview of the statute. So I think that, we'll see if other courts follow suit with that decision. So I think that there's still going to be some room here. It's just that there's going to be a certain kind of case that's just definitely off the table.
I'm glad you brought it back to what this actually might mean for prosecutions. And let's stick with prosecutions and how a certain set of facts might be addressed. So let's just clarify some things. Is the problem the timing of the agreement or the timing of the reward after this case, or in Snyder's case?
So
Sharon,
in my view,
Yeah.
I believe the way I interpret Snyder is that in order to be prosecuted under this statute, the government has to prove that there was an agreement that existed before the official act was done, that there was going to be a reward for that official act. And that's kind of how I see it. And again, that agreement can be approved through circumstantial evidence. In most cases, even with bribes, we usually don't have a smoking gun that says, here's the email that says I'm bribing you, right? So these cases are generally proven through circumstantial evidence, but I think that there's still that possibility. And, again, we'll see how the courts approach these situations.
Does it matter when the reward is given? So in the Snyder case, he got the reward after the official act. If he had gotten the reward before the official act, would the outcome have been different?
I think that the key determination is whether or not we can prove that the official act was connected to the reward, right? And that agreement has to be proven to exist before the official act was done, whenever the reward comes after. That's to me the key.
Because this has been broadly interpreted as allowing payments that come after an official act. But you're saying, and it sounds like James agrees, that it could encompass a reward that came before an official act, as long as it wasn't in explicit or implicit exchange.
Well, that's payment that becomes before an official act, that's just a bribe, right? Here's $10,000, now go vote my way on this legislation. That's just a bribe. The question is, what happens when the $10,000 is paid after? And so where you can prove that there was an agreement, okay, I'm going to go vote yes on your statute, and then I'll get the $10,000 later. That's a bribe. It's just that the bribe was paid later, right? So that's really what has to be proven here.
Okay, so you think this only applies to rewards given after an official act. If the reward was given before the official act, then it's no longer a gratuity, that's a bribe.
if you can prove up the quid pro quo, right? That there was an
Yeah.
agreement, that the official act, there's the, as was said with, with Sun Diamond, right? There has to be a connection between the payment and an official act. You have to have that connection, right?
But you can have
And
a
the other-
bribe where the reward comes after the official act too.
Correct.
Right.
Yes,
You
we
just,
yes.
with the bribe, you need the agreement, the quid pro quo, the agreement to, that one is for the other. But you also just remember that with respect to illegal gratuities, I mean, there's still an enforceable statute with regard to federal employees, right?
sure.
Federal officials. This particular ruling, because it's focused on the wording of a particular statute, 18 U.S.C. 666, really only impacts alleged gratuities involving state and local officials under this particular statute. There might be a state or local statute that would bar it, within their jurisdiction.
James, do you agree that the reward has to be made after the official act in order
No,
for it to
either
qualify
one.
as a
Either one. Either one. I think that's what Sharon said, and I agree completely. You have to have a prior agreement before the official act, but the payment could be made either before or after. It doesn't matter. It's irrelevant. Okay?
Yeah,
It's
we have
irrelevant
a-
if you're talking about a bribe, but if Snyder
Yes,
had,
if you're talking about a bribe,
but if
the
Snyder had
payment,
gone, if Snyder had gone to this company and asked for the $13,000 contract, and then he awarded the contract, but he said, this has nothing to do with that $13,000 contract. I'm just awarding the contract because I'm awarding the contract because they were the best bidder or whatever. What
if
about that?
there
Is that
was
still a
an
bribe
agreement,
or is that
if
a
there
gratuity?
was an agreement before the act of awarding the contract, that he would accept a payment for that, that payment could come before the act or after the act. It
Right.
doesn't
But what
have,
if there was no agreement?
then there's no
Because
bribe.
a gratuity, they're saying there was no, but is it a gratuity, even if it comes before?
Of course, yes. Yes,
Okay.
it could
So
very
the
well be
timing
a
of,
gratuity.
okay, so it could be a
A
gratuity that you
properly
could give a
worded gratuity statute, okay, could consider a payment before or after. Properly,
okay. So,
And
okay?
so the
and that
timing is not the
As a
dispositive
gift,
factor, is what
as
I'm
a
Right.
really
prohibited.
trying to get, because it's not
and
100% clear from the decision.
No,
and that's
I
how the
think,
federal statute works. And also, just to point out, one of the
But
differences
how
between
is what the federal statute work? That the
so the
timing
federal
that it
stat,
has
I mean,
to be after,
the payment can come at any time. It just, they have to be connected, right? And so the federal
they have to be
statute,
connected, but it's different from bribery. It's still a gratuity if it comes before.
right? And so the other difference is the gratuity part of the federal statute does not use the word corruptly, right? And that was one of the other
Right.
differences
No
that
mens rea
was pointed out, and why the court was like, that's why it's only 2 years. We don't have that problem. Clearly the federal government's like, we don't want federal employees taking money, right? And that's the decision we've made, and that's how we're going to do it. So,
Right. Because it seems like in some of these questions, there's a fair amount of uncertainty about how this decision is going to be interpreted and how it's going to
Yeah.
impact prosecutions. And some of these questions, I don't know that they've been fully resolved. Jenny?
and I was just going to say, I think Justice Kavanaugh introduced that concept at the beginning, saying generally, if it's a bribe, the payment is made the offer is made in advance of the official act. Whereas if it's a gratuity, the payment is made after. But that's, that kind of leads you down this. I totally agree with James and Sharon that the timing, the important thing with a bribery is the agreement, and the timing is less important in terms of the payment.
Okay, I want to talk a little bit about state and local implications of this decision. But first, I want to invite people, if they have questions, to drop them in the Q&A so we can start addressing them while we talk about this. So I want to direct this question at Sharon. Especially, we're a group that focuses on Illinois, corruption and ethics in Illinois. And Sharon is located here in Illinois, and this is an issue that has concerned her as well. I want to talk a little about what this decision's impact might be on Illinois state and local corruption prosecutions, both at the federal prosecutions and then maybe a little bit about how it might impact what state and local authorities have done and may do in the future. So Sharon, go ahead.
So I would say, in answer to your question, there's a huge question mark, right? It's just there's not a lot of clarity. We don't even know how this Department of Justice is going to approach corruption in general. We just don't know where that's going. They made some preliminary indications on their lack of interest, if you would say, in pursuing public corruption cases, but we'll have to see. So I think it's going to play out in a number of, it could play out in a number of ways. Here in Illinois, we recently had a very high profile corruption matter in the prosecution of former Speaker of the House, Michael Madigan. He was charged with a number of offenses related to the public corruption, and one of which was a violation of the statute that's at issue here. And as I mentioned, there was litigation in that matter around whether or not the statute continued to apply to the conduct that was issued in that trial because of the Snyder decision. And as I mentioned, the judge in that case said, look, because we have this stream of benefits theory of bribery, then I think that the statute still applies to this conduct. And of course, then the jury was instructed in a way that's consistent with this Snyder decision, and there was a conviction on that charge. And so, juries are going to be able to make these determinations. And so we'll see. But this is again a decision where you could see that there could be circuit splits that develop, and the law may change in ways that we're not anticipating right now across the country. So it'll be interesting to see. But as I mentioned, there's still going to be, the challenge of where there's the nod, wink, wink going on between the parties, and there's a payment after the fact. That's going to make it harder to apply this federal statute. So the question is, are there state statutes that could cover this conduct? And I think that there are in many states. There are bribery statutes that could still apply here. And the question will become, how aggressively will state and local prosecutors go after this kind of misconduct? Typically, it has been left to the federal government to prosecute.
And why do you think that is?
I think there are a number of reasons for that. I mean, I think part of it is just like, that's what the feds do. And people kind of are used to that kind of division of power between the federal government and the state prosecutor offices. The cynical in me says it's because state prosecutors are elected officials, and oftentimes they are reliant on the people that are the subject of these prosecutions for their own political careers, right? That's the cynical view of things. And so they're hesitant to take on these political corruption cases. And I think to a certain extent that could be true in a lot of cases. And that's why it's important to have, prosecutors and attorneys general who have the power to take on these cases, to have the integrity to do what's right here.
Great. So Ginny, how would you advise a client, say a company doing business in Illinois or a public official, to change their behavior, if at all, in light of the Snyder decision?
Well, you're still going to have, I would still, part of me wants to say, if you're going to accept money, or offer money, do it after the official act. But that's so cynical. I'm an ethics official, so I'm going to say, really, you shouldn't be. You've got to make sure, if you're doing business, in acquiring the consulting, services of a public official, which itself raises questions, right? Maybe, public officials at the state and local level shouldn't have outside consulting jobs, because I think it creates and fosters this distrust of public officers, because that's a vehicle for, funneling money to a public official. But you're going to have to be careful. You could still have aggressive, prosecutors who might want to look at these circumstances. Ultimately, I don't think if it mirrors the fact pattern in Snyder, it won't, it won't, it will probably be kicked out of court, but sometimes the investigation itself is very unpleasant. So you want to, keep those, transactions very separate if you're going to go forward with them at all.
Sharon or James, anything quick to add to that?
Nothing more to add, I think.
Perhaps to Sharon's point and to James's point earlier, there are still state and local laws that may address gratuities that people would want to be aware of as well, right? James, what do you think if you were a judge giving jury instructions in federal court, how would you instruct them to distinguish between bribes and gratuities in a federal trial?
Well, mercifully, I don't do that. Well, you have to prove both you have to prove not only that a thing of value was given to the public official, but you would also have to prove that there was an agreement by the public official to accept the thing of value in exchange for the public act, and it would have to be a proper public act. And if somebody, if it was after, I would say it doesn't matter. You would not, you would instruct the jury that it doesn't matter whether the payment came before or after. I really do read Snyder as being quite clear about that it doesn't matter that the payment occurs before or after. We just have to have the exchange, and the criminal intent.
We have a couple questions here that I want to get to. We've touched on this a little bit, but maybe I'll direct this one to James, since I think Ginny at least has weighed in on it a little bit. Doesn't this decision act as more of a guide to public officials on how to accept bribes? The court has basically laid out a bullet point list on how a public official can accept bribes without fear of prosecution. James, do you think that's true?
Well, I mean, that puts a negative spin on what, really our Constitution requires. Our Constitution requires that if you're going to charge people with a crime, that they have prior notice of what their conduct is. So in that respect, every single criminal law is a roadmap, okay, for how the government is going to punish your conduct. And the corollary to that is, if you don't do that conduct, how you escape punishment, okay, or application of that law. But that's in the nature of things, and I think one of the repeat kind of conceptual problem we're having here is, and really where the government fell down in Snyder, is they were using a bribery statute to punish accepting gifts, okay? And it just didn't fit. That's the problem. And so if the feds decide, and I think that they can properly do this, I don't object to their bribery or and other statutes that would apply to corrupt behavior as applied to state officials that take federal funds. I don't object to that. But if they decide that the problem is gifts, not bribes, but gifts, well, pass a gift statute that applies to state and local officials, like they have, that applies to federal officials. And then as I said, a properly constructed statute, gift statute, does not require an agreement, does not require criminal, corrupt mens rea. It's just per se, certain people to certain other people, for instance. Would catch McDonald, would catch Snyder, would catch really, the people that are being claimed to be bad actors, that it was an overreach. They used sledgehammer when they should use a hammer, okay?
Okay, two more questions that hopefully we can address quickly. Why isn't the jury system a good check on the feared overreach by the government?
Because we are entitled to advance notice under the due process of law to what conduct violates the law and what doesn't violate the law. We're entitled to that because we are free people. Okay, self-government is us governing ourselves, and freedom is how we exercise that. So if the government is going to punish behavior, we have to know in advance whether that behavior violates the law or not. And relying upon the beneficence of what Jenny would call all these corrupt officials, okay, to let us off the hook at some point, like not prosecute us or not arrest us, or, oh yeah, okay, the juries might not convict us, doesn't meet the constitutional test, okay? And I am not about to rely upon the beneficence of government, okay, to not apply overly broad and vague laws to us because some, one of these sweet government officials that are so corrupt they can't be given gifts, that they're going to let us off the hook.
Okay, although the question was about juries, not about
Oh,
government officials.
so-
but
Well, but see, a jury is exercising government power when they make their decision. They are
okay, only because of time.
government.
Only
They are the
Only because
government.
of time, I want to go to Ginny so that we can quickly get
Yeah.
to the last
So-
question.
One, just in response to Jane, who I just have to say, I mean, you don't want us to trust juries, you don't want us to trust prosecutors, you don't want us to trust judges, you don't want us to trust government experts, but you do want us to trust justices who've accepted millions of dollars worth of gifts and to administer these statutes. Now, you had your say, so I'll just have my say. The next question was what were my thoughts on the Stop Corrupt Gratuities Act and the No Gratuities for Governing Act? And I think both of those statutes would address some of the problems identified by the court in Snyder, and specifically the No Gratuities for Governing Act has a $1 million threshold for identifying what kind of gratuities would not be permitted. In other words, it has to be worth more than $1,000. I take note of the concern about fair notice because I am an ethics official or former ethics official who did years, it feels like training government ethics officials in the federal government over the rules for many, many years. So I do think ethics training should definitely be carried out for state and local government officials and for anybody else who would be subject to such a statute.
Well,
And it sounded like you thought the existing statute had fair notice, which is a disagreement that you had with James.
I do think that it should have been enforceable. I disagreed with the majority. I agreed with the dissent. But if now that we have this interpretation, if we're going to, if we need a statutory fix, these are two very good options.
Okay, this was a fantastic discussion. I learned a lot. I hope everyone else here did. I think this is exactly what we're talking about when we talk about civil disagreements. And I'm so grateful to everybody on the panel for joining us. I have a lot to think about. I feel like we could talk for another hour, but thank you so much, everybody, for joining. And thanks to our panelists for participating. Hope you join us for our next civil disagreements panel. Have a great day.
Thank you.
All right. Thank you, everyone. The CLE poll survey has launched, so please complete it. And if you're not seeing it, it should appear in the follow-up email that will arrive over the next 24 hours. Thank you so much for joining us. Bye.
Nice.